Well, our top focus tonight on what the court said about Umar, Khalid and Sharjeel Imam. The 2020 Delhi riots case. Why was bail denied to them? We decode what the Supreme Court said while giving bail to 5 others accused in the same case. Well, the Supreme Court has spoken, but it has not spoken in one voice. In a landmark and deeply consequential ruling, the Apex Court has delivered a split verdict in the 2020 Delhi riots larger conspiracy case. 2 accused remain behind bars, Umar Khalid and Sharjeel Imam. 5 others walk out on bail. A 2-judge bench of Justice Arvind Kumar and Justice N.V. Anjeria has denied bail to Khalid and Imam, holding that the prosecution's material meets the strict threshold of Section 43D5 of the UAPA, India's toughest anti-terror law. Their role, according to Supreme Court, wasn't only episodic. In fact, it was architectural. The court says prima facie the record suggests their involvement at the level of planning, mobilization and issuing strategic directions in what the police describe as a criminal conspiracy. At the same time, the court has granted bail to 5 others accused in the same 2020 Delhi riots case. Gulfisha Fatima, Meeran Haider, Shifa Ur Rehman, Mohammad Saleem Khan and Shadab Ahmed, making it clear that all accused cannot be treated alike and that bail must be assessed individually. This is not acquittal. This is not conviction. This is Supreme Court navigating the narrow, difficult space between national security and personal liberty. The key here is the UAPA bail threshold under Section 43D5. Courts can deny bail if the prosecution's case appears prima facie true. The Supreme Court has once again reiterated a very tough reality. Delay in trial alone does not automatically guarantee bail, even under Article 21. While even saying that in this case, the time spent in jail has not passed the constitutional impossibility. In other words, prolonged incarceration is troubling, but statutory safeguards under UAPA override that argument at the bail stage. Importantly, the bench has also left the door open. Both Khalid and Imam can apply again for bail either after protected witness evidence is recorded or after 1 year, whichever is earlier. Remember, these arrests stem from the 2020 Delhi riots case, a quick recap where 50 people were killed. The police alleged the violence was part of a planned conspiracy timed with the then US President Donald Trump's visit to internationalize opposition to the Citizenship Amendment Act. Sharjeel Imam surrendered in January 2020. Umar Khalid was arrested in September 2020 in the middle of the COVID pandemic. Nearly 5 years later, the legal battle continues. The ruling party has triggered sharp political reactions. In fact, the Supreme Court's ruling has triggered sharp political reactions. The BJP has welcomed the verdict, calling it a reaffirmation of the rule of law and demanding accountability from opposition parties that had supported the accused. Union Minister Giriraj Singh went further, controversially comparing Umar Khalid and Imam Sharjeel to those of convicted terrorists. There are others like civil liberties group and legal scholars who say they're alarmed. They argue that detaining accused for over 5 years without trial raises questions. In fact, the opposition has questioned what they are calling prolonged pre-trial, quote-unquote, incarceration. CPIM's MP John Brittas posted on social media, one languishes indefinitely without trial, other enjoys repeated jail vacations on demand. His reference to 15th parole to rape convict self-styled godman Gurmeet Ram Rahim Singh since his conviction. Remember, but one case is under UAPA, the other case is of a self-styled godman being convicted of rape. I'm being joined at this point by Dr. Rajiv Nanda, Senior Advocate with Supreme Court of India, Ellen Rao, who is a former DCP for Delhi, as well as Shifa Ur Rehman, who's an Islamic scholar. Thank you very much, all 3 of you, for joining me. Well, first to you, Dr. Rajiv Nanda. Let's start with the first main thing that he said, what the court seems to have said at this point. And it is interesting because the court says it's not just about death or destruction. UAPA is also beyond that. It encompasses the disrupting services and economy. This is one of the statements while actually going ahead and refusing bail to both Khalid as well as Imam, and saying that their role has been very architectural and not just sectoral.
Yes, of course. Today, Supreme Court has denied them bail both to Khalid and to Sharjeel Imam, while granting bail to others. The principle which has been reiterated by Supreme Court today is that these bail matters are not a right. In the normal course, what the law says and the settled law is that bail is the rule and jail is the exception. But here, the court has found that the material placed on record in the charge sheet and the perusal of the case diary shows that these two people were in prima facie involved in the planning, mobilizing, and the strategic planning of the 2020 riots. So the court is of the view that the UAPA law, the anti-terrorist law, being having the stringent measures. So the section 43D5 will apply here, and they will not be entitled to bail. There is yet another thing I must point out that while the trial is still going on, the basic criminal law says that nobody should be granted bail if he or she is in a position to influence the trial. Here, the protected witnesses are yet to be examined. And therefore, the Supreme Court has rightly said that let them be examined or let 1 year be passed. So then it will be decided whether they should be granted, because today they are in a position, or their group, or for that matter, the lobby behind them is apparently very powerful to influence such witnesses or trials. So therefore, they have been denied the right of bail, right, where others have been granted.
Atiq Ur Rehman, if I can get you in at this point, do you agree with how Dr. Rajiv Nanda is interpreting what the court has said?
No, with regards to Mr. Rajiv Nanda, I would like to differ from his opinion. And this is a very moot point, Sneha. That, say, for example, if Mr. Rajiv Nanda says that the witnesses are in absentia. Now, how can Umar Khalid influence the witnesses who are not, he does not know the name of these people? How can he influence? As far as the lobby is concerned, Sneha, let us remind the state, not the judiciary, that we, the taxpayers, Sneha, for 77 long years, we have paid to the government of India to strengthen our nation. And I am thankful for the Supreme Court that national security is such an important aspect in front of the Supreme Court. The same national security, can it be hampered by university students 2 and 5 in numbers?
Okay, no, but here's the thing, Atiq, you know, why you raise this question, there's something that the court has said, and it is important to bring this into light. The argument which has been made, whether it be in court or outside the court, has been that it's been a very long stay in jail. The court going on record today saying the stay in jail till now, even though the trial is not completed, is not against the permissible limits of the Constitution. Strong statements by the Supreme Court, by the topmost court, Atiq.
Neha, I am not questioning the Supreme Court.
No, we are not questioning. But if you are arguing that everybody, everybody has the right, here the Supreme Court is just nipping it at the bud, saying what's happened with the two of them is very much within the constitutional permits.
Because why the Supreme Court has opined upon this aspect? Because the government pleader, the attorneys have pleaded such a case in front of the judiciary that, and I'm thankful that 5 others have been released. Okay, we are ready for this. Now, what I am pinpointing is the arbitrariness of the state in comparison to individual rights. The International Court of Justice, if tomorrow addressing this particular issue,
Okay,
will
we'll
be
get to that
questioning.
when we reach that bridge, sir. But Dr. Rajiv Nanda, Elendra, allow me a few more minutes. Very quickly, Dr. Rajiv Nanda, how do you respond to what Atik is saying? Because even though what Atik is saying, the court really making several statements very strongly while denying the bail both to Khalid as well as Imam.
See, that is why Supreme Court has said prima facie. These kind of statements or the record should not be influencing the trial eventually. This will never be. These are observations made for denial or grant of bail. Bail means a temporary relief from the jail at the moment. So these are not going to influence the trial at all. Trial will depend on what kind of evidence will be brought by the witnesses or the prosecution otherwise brings in whatever material. Supreme Court has only observed that this is the prima facie, that the planning, mobilizing, and the strategic directions for 2020 riots is being proved against them on the perusal of the material brought. That is all.
Okay. Very quickly, Atik, here's the thing. The fact is the court today did not question the arbitrariness. It could have questioned the arbitrariness. It did not. Why? Because the court very clearly said the initial evidence, prima facie evidence that has been brought to them shows a very architectural role and not an episodic role. And that was used as a basis to deny both of them, Khalid as well as Imam, their bail while giving the other 5 bail. So if you are arguing arbitrariness, that's not holding in line with what the Supreme Court said.
But this particular argument, Sneha, is all the more reason to grant bail because already he was granted a 15-day bail. If he could have influenced, even we as a lobby must have influenced many things, but he was out on bail. This is all the more reason that the Supreme Court, and I'm not questioning. As a law-abiding citizen, I don't have a right to question the Supreme Court. I am questioning how the attorneys placed the case before the Supreme
Ellen
Court.
Rao, if you
national
can come in, Ellen
security
Rao.
aspect.
Atik, you heard both Atik Ur Rehman as well as Rajiv Nanda make their arguments. As a police official, as a senior police official who's also seen the Delhi riots unfold, how do you look at what's happened in the court? Because usually the court would make some very strong statements, calling out the lapses, particularly when a person has been in jail for a very long time and the trial hasn't completed. That's not what happened in court today.
Good evening, Sneha, to all your viewers and to the co-panelists, and Happy New Year to you all. If we analyze this today's Supreme Court order on bail of Sharjeel and Umar Khalid, we can only say that the Honorable Supreme Court has categorically said that this is a separate case and this is a seriousness of the case, and evidence on record has been analyzed, has been seen by the Honorable judges while passing this order. And these all seriousness and they have also differentiated the role of these 2 other who has not been granted bail and the role of other 5 who have been granted bail. So it shows that the Honorable Supreme Court has a very fair idea about the very fair decision granting bail to the persons who are entitled to that.
No, let me come in. And I want all 3 of you to respond to this. Ellen Rao, to you first. Supreme Court made a very important statement, and I want you to see how you all interpret this because you all are experts in your own realm. The Supreme Court said trial delay is not a trump card to automatically grant bail.
Yes.
A very, very strong statement and interpretation by the Supreme Court, because the argument for the bail was what many have been calling, quote unquote, the incarceration inside jail. But what has the court said? Because there is a trial delay, you do not have a trump card to automatically grant bail. First, Ellen Rao, and then let's go to the other 2 panelists. Ellen Rao?
Yes, Neha, I also heard that this is the point emphasized by the other parties, but court has categorically said that this is not only the ground, that incarceration is not only the ground. The court has to see other factors also. and that visualizing the video played in the court, and then other evidences on record showing that there a deep-rooted conspiracy of these two for this East Disney riots in 2020, then it shows that so many people have been, at least more than 40 people were killed, and so many hundreds of the people were injured. Both communities, not only one community. So it was a seriousness, and the criminal conspiracy aspect was properly analyzed by the Honorable Supreme Court, and this is the only reason. And UAPA Act is also stringent, as you rightly said, that UAPA Section 43, that section is very stringent to grant bail in such type of cases, and as particularly when the evidence is on record is so strongly put forward by the prosecution agency. So, in my considered opinion, that the Honorable Court has viewed all these, assessed all the points on the while granting bail to the 5% and not granting these 2%. They are holding that they are more responsible, and their role was definitely separate than other fives.
Okay. Yeah. You know, Atiq, let me just take this question with you, Atiq Ur Rehman. How do you look at this? A very strong statement, a very strong interpretation from the court that even for what many would call a draconian law like UAPA, it's one of the strongest anti-terror laws that India has, the UAPA. Even for that, the court saying trial delay alone is not something that can automatically grant you or make a ground for bail.
With full regards to the Supreme Court's Neha.
And I'm talking about the interpretation of the law, not about what the Supreme Court has said.
This is setting a very, very wrong precedent. Because in future, the judiciary, the courts, and the governments can, misuse this part.
No, if you're talking about this one, Atiq, staying with you itself, that's why I'm asking your second question as well. The court went on to say that it's not an automatic trump card. There are other things to be looked into. What are the other things they look? It's not about just death and destruction. You got to see whether this encompasses disrupting services, disrupting the country's economy, and so on and so forth. They go on to explain the different aspects that need to be looked into. Now tell me, how do you disagree with what the court has said? And I'm strictly talking about the interpretation.
Who am I surprised, Neha? All these charges have not been argued on the floor of the court so far. The argument so far was only regarding to bail. So once the charges are framed and argued in the court, then the things will come up. Now this is a very, very disturbing aspect coming from a highest court, because earlier courts have opined upon more upon individual freedom rather than not granting bail.
Okay.
What shall we believe in it?
Rajiv Nanda come in at this point, because Atiq Ur Rehman saying that this has been very disturbing for him and for others. But the fact remains that how can you decide on a bail under UAPA, a very, very strict law, a very strong law with very strong tooth? How do you decide for a bail under that law without really looking into the charges, evidence or accusations, allegations in this particular case? Respond to Atiq.
You first raised the interpretation regarding delay in the trial and the incarceration, the so-called incarceration. See, delay in trial per se in the normal course of a criminal law, yes, is a good valid reason for seeking bail, and courts have been granting bail when there is a delay in the trial and perhaps which is not attributed to the accused himself. But here, this is not the case. There are two things which the Supreme Court has kept in mind, perhaps. That is, this delay cannot be attributed, one, to the prosecution. It is the accused himself who've been seeking adjournments and thus causing delay. That's the first part of it. Second part of it is delay per se will not be entitling them to bail, because these are anti-terrorist laws. And prima facie, when there is material on record in the form of charge sheets, so there we cannot say that there is no material or very limited material or limited evidence is available. There is evidence in the form of documents or other statements which have been recorded during the investigation, which are there in the form of case diary and the reports which have been filed in the Supreme Court, which are good enough to deny bail even if there is a delay. So delay
Atik, do you want to
per se
respond to
not
this?
the
Because
trump
let's face
card.
the fact, you are questioning this. Atik, you are saying that why get into evidence? The charges have not been even framed. Why get into evidence at this stage? But the fact is the other 5 in this case have got what they have got in terms of a bail because of the limited evidence against them, which was not, according to the Supreme Court, the case for the 2. And the Supreme Court calls both of these people, Umar Khalid as well as Sharjeel Imam, as on 2 very different qualitative footings. I'm not using this. These are quotes by the Supreme Court.
Sneha, I'm just putting my case, saying that so far in the past 15 years, 20 years, our courts, especially the Supreme Court, has given us relief that they have coined their argument that bail is the rule and jail is an exception. No, this is overturned by the same court. What shall I believe? What shall I teach my students of political science? What is the belief of the Supreme Court? Jail or bail? Incarceration or the long trial?
But isn't
What
that
shall I
simple?
teach?
Isn't that simple? Basically, the court is saying today that it is not black and white. Ellen Rao?
Yeah, only saying that this incarceration is only the ground that cannot be held a ground for bail, definitely, because this UAPA Act is also there. Seriousness of the evidence is available on record. The court has pursued everything on that, and the prosecution has so many evidences in form of the electronic evidence as well as in statement of the witnesses, and all these things are available. And particularly, I'm not saying that the charges have not been, that is also a wrong statement. I think charges have been framed and the case must be on trial and prosecution evidence is maybe going on. And that's why the court has said that the evidences of the protective person should be recorded first.
Atik, quick response, and then I want to go to my last question. Quick response, Atik.
With a heavy heart, I will have to accept this, that so far individual liberty was important to the courts, and suddenly I am being taught by the Supreme Court, no, the circumstances must be different. I will take this Ismail by stride, Sneha, and along with this, I would argue on the Supreme Court's part that international justice demands justice for individuals, not the state, which can be arbitrary.
Okay, in this case, the court even addressed that. Court actually went on to address that as well in individual liberty versus the act against the state. Court actually went on to say that and said the both needs to be seen, and it's not only about individual liberty. But very quickly at this point, let me just bring in what some people in the opposition are saying. Ellen Rao, you may be the best person to respond to this. You have MP John Brittas, who today put out the fact, a social media post saying that here you have 2 people who are continuing to be in jail, and the other side you have another self-styled godman who is coming out. The 2 cases very different, but how would you explain a post like this as a police personnel?
Yes, the offences against both these persons are definitely separate. That godman, so-called godman, is not against the state. Here is that these 2 people are charged with the allegations of this sedition and then UAPA Act, the very stringent law of our land.
Okay.
So we cannot compare these 2 with that. And then moreover, the interim bail also, Mr. Umar Khalid has also been granted interim bail last year. That is separate.
All right.
Bail, regular bail and interim bail, both are 2 separate grounds. Separate. These things are considered separately, and the grounds on these bails are also.
Okay, we're totally out of time, sir. We're totally out of time.
Every time.
Atik, you quickly, both of you, maybe 15 seconds. Atik to you, then Dr. Rajiv. Quickly, 15 seconds each.
No, Mr. Rao, that's why the people need to understand that the state, if it is forming a law, the individual entity of a woman is more important, rather than the state. If somebody is, attacking a state for national security issues, here Baba Ram Rahim has attacked an entity of a woman. Are both not, similar?
Okay, all right, time up. Dr. Rajiv, quickly.
Yes, it is. Both the cases are incomparable. You can't compare oranges with apple. They are, of course, Ram Rahim's offense is very serious, but then that is not against the state. Mind it, these two have been charged with terrorism and destabilizing the state. This is the entire country involved.
All right.
These are not ordinary crime, which
Okay.
Ram Rahim has been charged with.
Okay, I think a very important judgment from the Supreme Court today. Also, as an anchor, I just don't intend to equate or justify what's happening with the self-styled godmen as well. That's a different debate. That's a different story altogether. But nonetheless, this is something that we will be watching very closely. To our panelists, Dr. Rajiv, Ellen Rao, as well as Atiq Ur Rehman, thank you very much for your time.